Attention embassy, attention.
Good evening, everyone, and dobry večer. It is such a pleasure to welcome you to this first webinar in our 6-part series on legal English. My name is Jennifer Euler from the Regional English Language Office, and I'm delighted today to present to you Ambassador John Sullivan, who will provide opening remarks for our time together this evening. Ambassador Sullivan has been in Russia as the US ambassador since 2019 and has a career that not only spans lots of public service, including roles in the State Department and other parts of the US government, but also as a partner in a US law firm where he focused on global trade and investment and US national security and foreign policies. In addition to private sector experience, he's had many senior positions in the Departments of Justice, Defense, and Commerce. He's originally from Boston, Massachusetts, and his legal training is from Columbia University School of Law. And he not only was there, but also served as a law clerk for the Supreme Court and for the Appeals Court, U.S. States Court of Appeals for the Fifth Circuit. So I know he'll have a lot to share with you today. We'll have some time to exchange some words about his experience before we have the pleasure of listening to our English language specialist, Daniel Sloan. Ambassador, please.
Well, thank you, Jennifer, and good evening, everyone. It's great to be with you. I'm delighted to have this opportunity to speak with you, particularly on a subject near and dear to my heart, legal English. It was 40 years ago, in 1982, I was on my way to go to law school, and I got a gift. And the gift was this enormous book called Black's Law Dictionary, which every law student and virtually every lawyer in the United States has and is familiar with. And so this has been a subject that has been at the very heart of my professional life now for 4 decades. And I'm delighted to kick off this webinar and to be with you. I first want to thank Sofia Baranova from the Legal English Center for taking the initiative to organize this learning opportunity with so many partners and participants from across Russia. I understand we have thousands viewing tonight, which is terrific. And thank you as well to the Institute of Advocacy of St. Petersburg Chamber of Lawyers for their support in making this series possible. It's important to me because I believe that the personal connections between Russians and Americans, grassroots collaborations between our universities and institutions, between lawyers, provide a strong foundation on which our official bilateral relationship is built. A key part of our embassy's efforts has been to help foster those connections by providing opportunities for teaching, learning, and practicing English. By sharing a common language, we can share ideas and find common ground with one another. I myself have broken out of my comfort zone and started, since I became ambassador, Russian language lessons here. I won't embarrass myself by using my Russian this evening, but it's been a lot of fun and a very difficult undertaking. Jennifer, who kicked us off as our regional English language, heads our regional English language office, which offers a wide array of free programs for English language learners at all stages. And as I said at the outset, as a lawyer myself, I'm particularly gratified to see this special series on legal English and the robust interest in this topic. It's undoubtedly the largest virtual meeting I've participated in, at least as ambassador. We're proud to be working together with training institutions, associations of law, and legal communities in Russia to make this series accessible to all free of charge. And the webinar series will provide a deeper look at the language of the law with an American English language specialist expert, Professor Daniel Sloan, in law and in government language matters. And we're delighted to have Professor Sloan with us. As lawyers, we have a unique obligation to our clients and into our profession to pursue truth, to seek justice. And as I say, it's an honor for me to speak with you today. And I look forward to hearing about the important contributions you will all make for your clients, your communities, and beyond. As I'm learning in my Russian language training, and as you all know, language learning requires commitment, determination, and persistence, just like the pursuit of justice. But it's worth the investment. So I know, I'm confident you will enjoy and get a lot out of the course. And with that, let me turn it back over to Jennifer.
Thank you, Ambassador Sullivan. We've taken the liberty of kind of gathering some questions in advance, knowing that we may have 6,000 people watching this live stream. And many of them are new to the profession or future lawyers who are in training. And I wonder if you might tell us a personal story. You told us something already, but about your experience as a lawyer or maybe as a diplomat that involves the importance of language. Why is it important to be precise with your words, particularly in those professions?
Well, language is a reflection of many things, including our thoughts and how we organize them. And if we're disciplined, our language is a reflection of organized, rational thinking, which we express in words in precise and in a concise way. I often like to cite a former United States president, Abraham Lincoln, who gave a famous speech, one of the most famous speeches, if not the most famous speech in American history, at the dedication of a cemetery in the midst of the U.S. Civil War in 1863. It's called the Gettysburg Address. It summed up the creation of the American Republic, our experience to date, and what we had aspired to as a people. He expressed all of that in 272 words. He was preceded in his remarks by a United States senator from my home state of Massachusetts, who spoke for 2 hours. And no one remembers what Senator Everett said that day, but every American can recite the opening lines from Lincoln's Gettysburg Address, which was 77 years ago today, which is, dating to the foundation of our republic. Lawyers in particular need to pay careful attention to their language because, as I say, it's a reflection of our thinking, our principles, the arguments that we're trying to convey. Learning legal English is particularly challenging. I remember starting law school and again making the connection between language and thought and ideas, and being told by my law professors that what they were trying to teach me was how to think like a lawyer. And if I thought like a lawyer, that also meant I needed to express myself like a lawyer and be precise in my language. And I remember one of the first classes I had in law school on civil procedure. In the one of the part of the discussion, again, this is 40 years ago, but it's memorable. I had a memorable law professor teaching this basic course on civil procedure, and he focused on the word claim. And we can use the word claim in many different ways in legal English or in English generally. I can claim something, which means I can assert something. Or I can, as we say, as is indicated in our federal rules of civil procedure, if you want relief from a court, you submit a claim for relief. So a claim for relief is really different from, say, using claim in that context is different from using claim in the context of I contend, I assert. But being precise in how one uses that word is just an example of how important it is, particularly for legal English, to be precise in our language. And if I could finally, a large part of my law practice, my work as a lawyer was focused on written language, and that includes then continuing on in my my current position as ambassador. I won't say which document it was, but I have in my experience here as ambassador, calling on my training as a lawyer, reading a very significant document that the United States was about to submit, to make public, and noticing that there was a word missing. It was a typographical error. It wasn't a substantive or grammatical error, but nonetheless, it was a significant public document with a glaring word missing on the first page from a sentence that I am sure hundreds of people just glossed over and never noticed. And I was proud of myself and thought of my training as a very, very junior lawyer, a so-called associate at a big law firm, proofreading documents late into the night. That my contribution, at least in that connection, was correcting that document so that the record accurately reflected what we were trying to convey as a government. But anyway, some thoughts, Jennifer. Back to you.
No, I think that's great. You know, what you had to say about being careful and concise and precise, and how those words reflect thought is really important for this audience. And I love the examples that you gave here. I wonder, thinking about working in a language that is not your native language, if you have any advice that you would like to give for these Russian lawyers who are working in English, maybe from your experience, or maybe one of your insights of working with lawyers that speak other languages.
Boy, I find it challenging to express myself as a lawyer in English. If I were trying to express my thoughts, my legal position in a language that wasn't my native language, that's extremely challenging. I find it difficult enough to say remember to say dobre večer to my friends here at the embassy when I try to show off my colloquial Russian. It's very challenging, but it's vital for anybody who is interested in practicing law, particularly because just as, over the years, French was traditionally the language of diplomacy. English has become, over time, the language of commercial relations for the most part, whether it's because of the influence from centuries ago of the English mercantile system and the developments in the post-World War II era, at least in Western economies, the dominance of the U.S. economy. My experience has been in international law practice that a lot of what I was dealing with were documents in English. So it's extremely important, particularly for lawyers who are interested in commercial relations, to have familiarity with English and legal English in particular. And the other thing I'll say from my perspective as a partner at a big law firm, it's the sloppy way to go about things. The easy way to do things is to not economize and to think that the longer the document, the bigger the bill for my client. In fact, the most effective advocacy for a client is conveying in the most concise, precise way possible the idea that needs to be conveyed. It's the easy way out is to just say more. The more difficult way is to find exactly the right words to use to convey that message, whatever the idea is, whether it's a principle of contract or an argument in a brief or an argument to a court, is to convey that principle in as concise and clear a way as possible. And that's hard. The easier way is to throw a lot of words at the court or on the page, but it doesn't necessarily advance the client's interests or lead to clarity in communicating the idea that needs to be communicated.
Well, I have to thank you for really good advice, Ambassador Sullivan, and for the pleasure of speaking with you to open this great series. And I'll add a piece of advice to yours, which is attend all 6 of the webinar series to learn more about legal English and take advantage of resources. But thank you for your time. And I think we'll go ahead and get started with the webinar this evening. It's our great pleasure to be hosting this series of legal English webinars together with the Legal English Center, but also with a fantastic English language specialist. So I'd like to introduce to you now the facilitator for this evening and our next 5 meetings, Dr. Daniel Sloan. He is a State Department English language specialist and an adjunct professor at Pepperdine University, Caruso Law School. He specializes particularly in LLM and MDR programs, educating legal professionals, academics, students, and scholars at the Strauss Institute for Dispute Resolution. He lives in California, teaching business administration and economics full-time at Simpson University. He directs a Master's of Organizational Leadership program. He's also taught at UCLA's American Language Center, international universities, as well as being academic faculty at several foreign U.S. embassy and consulate locations where he's been a specialist or a fellow. During his international service, Professor Sloan spent almost a decade in China, Laos, and Southeast Asia, where he educated and consulted the senior staff of foreign governments. His work included the ASEAN Integration Project. He's traveled all over the globe, and now he'll be working with a fantastic group of Russian legal professionals through this webinar series. Thank you very much for joining us. We hope you'll continue to join us. Daniel, we look forward to learning from you.
Great. Thank you so much. Thank you for the welcoming. And I'm just honored, and it's a pleasure to be here. Greetings to our Russian partners. And I'm here in California right now and preparing to go through some slides with you and facilitate this first session. And I first off want to echo the comments by the ambassador. Brevity is very important. Being concise in what we do, especially in foreign language situations. Translation is difficult. So I'm going to go ahead and begin my presentation here, and you see there a quick quiz for you. In this first part, what I'm going to do is this may be things that you already know, but we're going to go ahead and just kind of give a foundation, a base to what we're starting with in this series. So, how many branches of government are in the United States, and can you name them? Well, I've got them listed here for you. There are 3: the legislative, executive, and judicial branch. We're going to use these in some of the work that we're going to do coming up here soon. So it's important to know where they fit in to the process here. Each of the systems that we have, the federal and state, has its own Congress and House. Congress, for the federal, it has a Senate and then the House of Representatives. And each state has its own set of legislature, which is the Senate and Assembly, for example, in California. For the executive branch, we have the president who presides over the federal, and California, for example, we have a governor. Each state has its own governor. So the judicial branch, how do those appear? What do they look like? How do they compare and contrast? So for the federal side and the state side, we have the Supreme Court, U.S. Supreme Court, state Supreme Court. Each one of the states has a Supreme Court system, just as the federal. We have the circuit courts, and we have state courts of appeal. We have district courts in the federal system, and we have state trial courts. And then we have other federal courts, and there's a whole host of different courts that we have there, from the Court of International Trade to the federal circuit courts, bankruptcy courts. There's a whole array of different federal regulations and oversight that our federal courts have, such as magistrate courts, U.S. tax courts, courts of federal claims, courts of appeals for veterans, military courts. There's quite a list of various authorities. So what are federal cases, and are they limited to jurisdictions to what the Constitution allows? So such as federal crimes or treaties, civil suits between citizens of different states, bankruptcy, and review of federal agency decisions or actions. And all of the judges in the courts are nominated by the president and approved by the Senate. So that's how that system functions. For the state courts are of general jurisdiction and decide issues of like state statutes, laws, civil and family issues, and most judges are elected. So the federal laws, regulations, cases, and then a separate lower system of 50 states is the way to look at it. They regulate, the 50 states regulate the laws and cases in each of these systems, jurisdictions. Case law is part of the body of law that citizens in courts must follow. So I have a question here, and let's see if this will function properly with this many people. So if you have the system on your phone, or if you have it on your computer, you can answer this. What we've just gone over. How many branches of government are there in the United States? And can you name them? If you see at the top up here, it says, name the 3 branches that start with an L, E, and a J. Time's up. Did you get them correct? Legislative, executive, and judicial. So moving on, we have the Supreme Court, how it works. Supreme Court is the highest court in the country, located in Washington, D.C. The head of the federal judicial branch of the federal government, responsible for deciding whether laws violate the Constitution, and in session for in early October until late June or early July. So it has a time frame in which cases are actually heard. You probably have seen this or studied this as part of your law degree. I have another question for you here. Let's see how many of you can get this one. Looks like some people have joined. Are you ready? What are the sources of law? And how would you order the hierarchy? How do we order these as to which ones are seen as the most primary? What is the order from top to bottom? Let's take a look and see what we have. So we have the US Constitution, okay, the little hierarchy over here in this pyramid, the statutes, regulations, and the administration. So the US Constitution itself was created in 1789 with 1791, the Bill of Rights, plus more amendments since that time. The Constitution creates multiple branches of US government, divides the authority between federal and states, and grants certain powers to the government, such as the power to regulate commerce with foreign states, among several states, and with Indian tribes, the Native Americans that were here originally. It also limits the federal government, such as the Fifth Amendment. And I think you probably have heard of the Fifth Amendment if you've studied American law. No person shall be deprived of life, liberty, property without due process. Big part of American law Yes. Ah, okay. You don't see the voting. Okay. Okay, we'll have to do that on the next one. Got it. Thank you. My apologies that it's not functioning quite right, but that happens. New technology. So I'm glad that you're voting. That's great. So continue to do so. If it works in the chat, that's wonderful. So part of what our U.S. Constitution helps decide are limits on the federal government, which is a very interesting aspect of American law. So our famous First Amendment is something that's also very important. So Congress shall make no law respecting an establishment of religion, and includes rights for free exercise of religion, freedom of assembly, and free speech. All important, very important aspects of American life. So the U.S. Constitution creates multiple branches of government, just to kind of review, divides authority between federal and state government, gives limited powers to the federal government, such as the Commerce Clause, Due Process Clause, the First Amendment. And then the second one, number 2, is statutes. Number 3 is the regulations or administrative. And then, of course, the fourth one being the judicial decisions, common law or case law. So that kind of puts us in order so that we can begin to understand what we're going to be doing in terms of writing. Okay, let's try this one and see if this will work. This is for can the drug user be arrested for breaking the law? And it's in regards to a case to where a person who is in a state where the state is allowing drug use, marijuana, and has a doctor's prescription, can they use the drug legally and not be arrested for federal law? So that's the question here. And I see there's a few answers. You could probably see them here. Sophia, is it showing up here on your side? Okay. No, they are voting for it. Yeah, they are voting. Okay. Good. Okay, so far we have yes for 50%. Looks like we have more voting, and go ahead. I'll leave it open here for just a couple minutes and we'll see what we have, or not minutes, but a couple seconds anyway. So we have 50% of you that say yes. Can the drug user be arrested for breaking federal law? Unsure is 13%. No is 38%. So since it is against federal law, yes, you could be. This was the case in the past where people in California who were using medicinal marijuana, is what we call it, as a medicine in the state, felt it was legal. The state legalized it for use, but the federal law says, no, you cannot. So it creates a lot of problems in trying to administer the law when you have two systems, one that contradicts the other. Let me see if I can bring that up here. So the federal law, just to refresh, we have the Supreme Court, we have a Court of Appeals, and we have trial courts. And the same thing goes for the state system. So they each have, there's 3 down here at the bottom. That has nothing to do with the 3 levels. It just means that there are many states, 50 states, that have the same similar type of system: the Supreme Court, Court of Appeals, and trial courts. Okay, let's try another question here. At which level is case law made? So at which level? Supreme Court, Court of Appeals, trial courts, or both A and B? So we have Supreme Court was some votes. We had none for the Court of Appeals. We had trial courts, and then both A and B is the correct answer, right? So they are both appellate courts in that sense. There we go. So far it looks like Heartstorm is the fastest and is ahead for the leaderboard. Good job. Well done. So which level is case law made? It's at the appellate level. To refresh, this includes the Supreme Court because it is a court of appeal. Okay, binding precedent or stare decisis. I'm sure you've studied this. Just as a review, means to stand by that which is decided. In other words, courts need to follow precedents in American law. The idea is that presidential decisions should be followed by later courts. That would create consistency and predictability in the law. So in a sense, what we have here is the appellate level that is setting a precedent. This is important because we want to know, does that mean all previous cases are precedent? Do all cases rise to being that of precedent? The answer is no. At the trial court level, decisions are not binding on future litigants or anyone else, not before the court. So even at the appellate level, court level, not all decisions are binding law. Only published opinions create law. Supreme Court is also an appellate court, as I said. So it's an important aspect of it. So the courts don't decide cases in a vacuum is a main key. They look at what's come before them, other cases with the same legal issue and similar facts were decided in the governing jurisdiction in an appellate or Supreme Court. So it's important to know that these things didn't happen in a vacuum. They've happened in the past. They've been decided by the appellate court, and that's what we're going to go looking for for the case in front of us today. Courts are required to follow decisions of higher courts in the same jurisdiction. Accordingly, the cases which are both from a higher court and in the same jurisdiction are considered mandatory authority. We're going to be looking at these as far as mandatory and how they're applied. Binding precedent is higher authority from courts in your jurisdiction. Courts are required to follow decisions in higher courts in the same jurisdiction. Okay. And we're on to something here about compare and contrast. So how do civil law judges use cases? And we're looking at between civil law and the common law. So number 2, if cases are not only advisory, but mandatory and binding, how will this affect the way they're used by court? And 3, if case law is binding, how will they be taught in law schools? Or if there are new cases being decided every day, how does that affect the way law students learn? And you can see the problems there, because if the cases are changing based on new precedent, then it's difficult to be a law student, because then you have to learn not only the law that's being taught, but to keep up and to know how to find new precedent in order to use. So those are some of the things we're going to talk about, and then how we apply those to what we're going to be writing. So first, compare and contrast. How do civil law judges use cases? The main difference between the two systems is that common law countries, case law in the form of published judicial opinions is of primary importance, whereas civil law systems, codified statutes predominate. So we look at what has happened in the judicial opinions, published opinions, and that's a big part of it. It has to be a published opinion. Whereas in civil law jurisdictions, though there are hybrid systems, they use cases as advisory, not mandatory. Common jurisdictions, like in the US, use binding precedent, which is higher authority from courts in your jurisdiction. So when briefing a case, your goal is to reduce the information from the case into a format that will provide you with a helpful reference in the case and for review. Most importantly, briefing a case, which is what we're going to be doing in our writing, you will grasp the problem the court faced or the issue. Okay, the relevant law the court used to solve it, which is the rule, and how the court applied the rule to the facts. So it's the application, and then the outcome, the conclusion. So we use this information differently in common law than you're using in your civil law system. You will then be ready not only to discuss the case, but compare and contrast it to other cases involving similar issues. Before attempting to do a brief, there's some things that you should do. So before you attempt to make a brief on a case, first thing you want to do is read the case at least once, follow the IRAC method in briefing a case. And that's what we're going to be using today, is IRAC. So if cases are not only advisory, but mandatory and binding, how will this affect the case or the way they are used by a court? Well, some guidelines are mandatory unless there are grounds for departure. So there may be some grounds the court will find that they can move away from mandatory guidelines, and those are pretty strict. But there are some guidelines to go around the procedure. Some guidelines aren't only advisory, although judges are required to at least consider them. They can't just not take them into account. They do have to evaluate whether they do apply or not. And in each of these system types has various variations, yielding a continuum, not a dichotomy. So it's not binary. There's not one or the other. You have to use it or you don't. It's not mandatory or advisory. There could be some leeway, some ability to use it in a more viable or pliable way. What this means is common law judges have less discretion to figure out what the law means, as they are bound by precedent. More predictably, less flexibility for the judge. It's a way of looking at it. In case law, if case law is binding, how will they be taught in law schools? And that's a big issue. So if there are new cases being decided every day, how does that affect the way law students learn? Well, in law school, instead of learning only black letter law, you'll need to learn the cases. However, because cases will always change, you need to know how to find, understand, and critically synthesize the cases to form the current law. You cannot just look up the code. So there's quite a much more extensive use of research, and you have to keep up with current cases in order to know how to apply them. And then we're gonna use IRAC in order to give us a better way of reviewing the case in a very brief or concise method. So the issue, what is the issue? What is the question that being presented to the court is what we're asking. What is the issue being presented, the question being presented to the court? Usually only one issue will be discussed, but sometimes there will be more. So what are the parties figuring out? What are they fighting about? And what are they asking the court to decide? Those are the kinds of things we're asking in an issue. We have, for example, the case of the assaulted customer, and the issue of trial court to decide might be whether the business had a duty to the customer to provide security patrols, for example. And to answer the question will help ultimately determine. The rules, which determine the relevant rules of law, are that the court uses to make its decision. These rules will be identified and discussed by the court. Okay. There may also be more than one relevant rule of law to a case. For example, in a negligence case in which the defendant argues that the plaintiff assumed the risk of harm, the relevant issues of law could be that the elements of negligence and the definition of the assumption of risk as a defense, and then application and analysis. Most important portion of the brief. Okay, how courts apply the rule to the facts and analyze the case. So it's important to predict outcomes in future cases involving the same issue. We have to look at what happened in the past and then try to compare and contrast to see how those issues were reviewed, the rules that were applied, and then how they apply to our particular set of facts in our case, which can be completely different from what they were in the past. Then we have to try to evaluate that. How do they compare and contrast? So in using it in law school, because this is because in law school, even if you learn the current state of the law, by the time you graduate, the law may have evolved with the case. Thus, you must learn how to find the law. And most importantly, how to synthesize, which is what we're going to do with Iraq, all the codes and cases to figure out what is the current state of the law and how it should be applied in your client's case. In law school, your professor will challenge you to think about if these facts are different, how to argue what the law should be. So thus, Iraq is a way to understand common law precedent so that you can use it to develop your synthesis of what the law is and how it should be applied to your client. So I'm sorry to be reading all of this, but I want to make sure that we have a base and a foundation which to build on for what we're going to be doing with Iraq. And here it is. So Iraq is basically a rubric for legal analysis. It gives you skill sets that you can use to think like a lawyer. And just as Ambassador Sullivan had discussed, how do we think like an attorney? How do we think like a lawyer in using words accurately and concisely and ideas? And then, of course, you are using them to translate from your language into English. So what are the facts? That's the first thing we want to find. And we can actually add the F in front of the Iraq, and we call it FIRAC or FIRAC in another analysis tool. So the facts are what we do to discern which facts are relevant. So going through the case, it could be very complex. In many cases, there's a difficulty in determining what should I count as relevant, what's most important. The issue, what are the issues that need to be pointed out to the court that are going to be argued in front of the court? The rule determine the governing body. And then analysis tools. Apply the governing law to the facts to generate assessments or arguments. In conclusion, use the analysis tool to make recommendation to fit your client's interest and goals. So because cases are revolve around legal issues, we use Iraq. And since we have a case law system, with many different cases, we need to know a way to organize and understand the cases. And then useful organizational tool to analyze issues for legal exam. So if you have to take the law exam, bar exam, you might use these for those more predominantly in law school or for a client or for a court. And because the U.S. uses case law, you need IRAC to help you understand and synthesize the case. Tell your client what the law is, and then argue to the court what the law should be as applied to your client. So there's a couple of uses there for your client as well as for the court. Case law is always about two sides. You need to determine what is the issues between them. You might use IRAC in the information in the following issues: assessing the merits of a prospective legal matter, review of case law, and research. What is necessary to win a case for your client? What kind of issues were involved in prior precedent that maybe you need to bring up that are necessary so that you know how to gather information from your client or how to use what your client is providing you. And then all aspects of legal writing include case briefs, legal memorandas, and appellate brief. So kind of a distinction here is looking at this in a different way. With precedent, how do we use these cases? We use them with an analogy or distinction like apples and oranges. You probably have heard that: apples, oranges, and limes. So with precedent in previous cases, there are going to be a unique set of circumstances. And there's a unique set of circumstances might be that, for example, if we had a dog bite and the client in the previous case, the precedent setting case, was claiming that they were injured and needed relief because of an act on the part of the defendant's animal. There might be a case to where you could show that the animal had previously injured other people. It was being mistreated or beaten, or some aspects of the case, the facts applied to how they applied to the case, and then the decisions that were made, the rules that were used, application of the law, and then you have the conclusion in the precedent setting case. For your client's going to be somewhat different. You're going to have other issues, and you're going to attempt to compare those facts and show how what rules are to be applied to your client, issues and rules, and then what kind of conclusion you think should be applied in your case. So it's not going to be apples to apples, in oranges to oranges. You might have a pineapple and a banana, okay, for an analogy. They're going to be a little different in your case, and you're going to have to argue how your case is similar or why the differences are what they are and how they matter to get the conclusion for your client to be successful. So it's a way of looking at the common law analogy for the precedents. So there's a practice case that I've attached here, and maybe Sophia, do you have that in the chat area or somewhere where they can pull that? Sophia or Jennifer?
Okay, Daniel, can you hear me?
I can hear you.
Yes, so we sent over the case, and I hope someone has read it. But if you can just remind couple of words, because someone might not have not seen it. So, but actually, it was attached.
Okay, so it is of interest, and it's attached there somewhere in the chat or online, and it's a very brief case an Iraq case brief, Rail versus Kadena. And in this case, it was published in 1979, October 23rd, 1979, Court of Appeals. And it's a case that you could use as a precedent for an example, okay? So it's a good example of a case where a defendant was accused of inspiring someone else, his nephew, to beat a man. So the defendant in this case was Emilio Cadena, a non-active participant in the battery of a plaintiff, Eddie Rael, appeals to the judgment of the court, finding him along with the active participant jointly and severely liable for battery. And it was a case to where in American law, if you are encouraging somebody to beat someone else or to injure someone else, then you can be held liable for that. And you might look at this case and say, it's a very interesting case that in America, the person who doesn't actually touch someone else can be held responsible, can be held civilly liable. So that was the case here. The lower court, the trial court, found in favor of the defendant and found that the plaintiff was held responsible. And it was appealed. It went to appeal in front of the Court of Appeals of New Mexico in 1979. So that's a good precedent-setting case to look at. The issue on appeal is whether a person present at battery who verbally encourages the assailant but does not physically assist him is civilly liable for the battery. Okay. And what had happened here is the person who was found responsible, even though he wasn't there, was saying things in Spanish like kill him, hit him more. And the trial court, sitting without a jury, found Emilio encouraged Manuel, the man who did the beating, was responsible and upheld the lower court's ruling. So it's one of those cases where it went from the trial court to the appellate court. The court upheld the decision. And as you read through this, as I said, you'll find that it's very concise the way that it was written. There was some evidence that was presented at the appellate level. The court went ahead and went with what the lower court had decided, even though more information was provided, because they felt it wasn't adequate for overturning the case. So this case, how could we use this in our situation? Well, we may have a case to where, like today, we have a different set of technology that we're using. We're using Zoom here in order to communicate. So it's possible that maybe a client over Zoom is encouraging someone else, or over chat or over other new technology since 1979, that a client may come to you and say, I'm being sued for causing harm, even though I did not do the physical action of beating someone or injuring them. And you might look to this case to say there is precedent there that you could be held responsible, you could be held liable, and use this case as a precedent to make that argument. And you can see that it's not apples and apples. It's not apples and oranges, because in this case, the new case, we're using a different set of issues, a different set of facts that are involved. But we're trying to maybe apply the same rules to come out with either the same or a different outcome for our client. Okay, so I was going to give a break there for you to take a look at it, but I think we'll be okay. Do we need a break at this point? We're about 1 hour into our first session, or should we continue? Sophia?
No, Daniel, sorry, we don't need a break. We can just go on.
All right, we're going to continue on. So, yeah, student case brief. So now that we've gotten the underlying foundation set, We know the student case brief for a law school would include the facts, the case name and citation, just as I've shown you on the case here with Rail versus Cadena. Okay, so you'll see in there it's going to have the procedural facts. It'll have the case name and citation, of course. Appeal of summary judgment motion. It might have the legal material, historical facts, the statement of the case in a short summary. All of these are going to be part of what is included. And move forward here. You'll have the issue, which is the question or questions the court must decide. What is the court trying to determine? You need to submit that. So you may maybe multiple issues or sub-issues, and it's up to you to discern what are the issues the court must decide. So the rule of law on which the court's bases its decision, the Constitution, the statute, FRCP, the judge-made law or cases, the restatement or a combination, a restatement of the rules or the combination of all of these things. Analysis, what is the court's reasoning? Why should the court decide in the way that is most beneficial to your client? May organize into one, the facts and arguments of the plaintiff, then the facts and arguments of the defendant. And remember, this is for two sides. So what are the becauses, the pros and the cons? A conclusion, the court's holding. The court did legally or procedurally. Okay, the result. What the court did legally and procedurally to conclude or come to a result. So that's called FIRAC. And we use that to write a case, a brief. So we're going to try that if you were doing this with the Rail or Cadena case, what could you put here? So in this case, we might do this, compare our case briefs, procedural facts. And we have Eddie Rail sued Emilio and Manuel Cadena for civil battery. Trial court found Emilio jointly liable with Manuel for the battery. Emilio appealed the judgment of the trial court. So those are procedural facts, very succinct. You see up there at the top, we have Rail and as the appellee and Cadena as the appellant, 93 New Mexico, and we cite the information from the case in 1979. What are the facts? While visiting Emilio's home, Emilio's nephew, Manuel, beat Raul. After the attack began, Emilio yelled to Manuel, "Kill him," and hit him more. Emilio never actually struck Rail. Rail was hospitalized. Very concise again. So the issue under New Mexico law, can a person be liable for battery when he is present during the battery and encourages the perpetrator of the battery by yelling, "Kill him," or "hit him more," even though he takes no actual part in the physical beating? And the rule is yes, an individual may be liable for battery by encouraging or inciting the perpetrator by words or acts. So that's very important because it does set that precedent. There's another case, which is Lucy versus Zimmer. And in the facts in that case, defendant husband wrote and signed a contract to sell his farm to the plaintiffs and persuaded the defendant wife to sign by telling her the contract was a joke on plaintiffs. When plaintiffs attempted to finalize sale, the defendants attempted to deny the contract on the grounds that the defendant husband was drunk when making the contract, and the contract was a joke on the plaintiffs. the plaintiff sued for a specific performance. So the court found for the defendants, what was the issue? Was there a valid contract? Okay, was there a valid contract? That's the issue. So it's another example of ways of using this. The rule, yes, the mental assent of the parties is not requisite for the formation of a contract. In other words, other acts of one of the parties have been but one reasonable meaning. His undisclosed intention is immaterial except when an unreasonable meaning which he reaches to his manifestation is known to the other party. In other words, if you're drunk, that's not really a relevant fact in this case, because the mental assent of the parties is not requisite for the formation of the contract. So we're using this case to establish a way of putting it into a concise format or a case brief. So the conclusion, the court held that the defendant's true intent in agreeing to sell their farm in the case of Lucy and Zimmer was not determinative so long as their words and actions warranted a reasonable person's belief that a contract was intended. Under the objective theory of contracts, plaintiffs reasonably believed the sale contract was a serious business transaction. The evidence suggested defendant husband was not too drunk to know what he was doing. So they claimed after the fact that it was a joke and claimed that their alcohol inebriation, because they were drunk, was a cause for getting out of the contract, and the court would find otherwise. But it's a way of taking a very complex issue and putting it in a brief by using Iraq. So for the Rail Cadena case continued, what is the analysis? What is the reasoning behind this? Liability for assault and battery extends to a person who aids or encourages the act. The act of verbal encouragement at the scene may give rise to liability because they were giving a reason. The perpetrator is goaded and encouraged at the behest of the person encouraging the battery. Here, and you can see in the way that this is written, we're giving very concise, but also very direct guidance. Here, Emilio verbally encouraged Manuel to beat Rael and to continue to beat him. The battery may not have occurred or continued but for Emilio's encouragement. So the way that this is written, we're giving the reader, in this case, maybe our client or the court, very specific directions in the words that we use in order to direct it. Therefore, Emilio had some part in the beating, even though he never physically contacted Rael. Thus, Emilio is liable for the battery for aiding in its commission, encouraging the act. Okay. So the appellate court confirmed the judgment for battery, and that was the case that I provided to you in the chat. Very interesting case. A person who is not present but inciting the battery via Zoom call, and a person who's present but says, "Yeah." Okay, these can lead to liability, and we would probably look at this case or others like it as a precedent for establishing the rules that we're going to use in this case. So, how is FIRAC used? We could probably have you put this in the chat, and Sophia could probably take a look at this. How is FIRAC used? Okay, so in a case brief, you're using it for yourself. That's the audience, and the purpose to prepare the class for examinations. So what structure should you use? Should you use FIRAC or IRAC? Which structure? And then the log exam essay.
Okay.
Audience. Sure.
So do you want me to put a question over here? Yes, which
Is it FIRAC or IRAC?
okay, just a moment.
Yeah. Perfect. The case brief for yourself as the audience, and the purpose to prepare the class for exams. So are we using FIRAC or IRAC in that particular case brief? For the next one, for law exam essay, that is for a professor, and the professor uses it to determine your ability to do legal analysis and provide a well-written and organized essay. Are you going to use FIRAC or IRAC in that case? And the last one is court opinion. So the audience for the court opinion is our litigants, other judges, lawyers, professors, law students, other branches of government, and the public. And the purpose for that is to inform the audience of the holding or outcome and the reasoning of the case, to persuade that audience of the correctness of the result. So what are we going to use in that one? FIRAC or IRAC? Are we ready for the results?
Well, everyone says that some people say that FIRAC, and FIRAC for the first, and the third,
Number one,
and IRAC for the second.
Okay.
So mostly FIRAC. Everyone says it's FIRAC.
How about for the case brief?
So for court opinion, we should use FIRAC. For case brief, we should use, well, everyone is saying FIRAC. FIRAC.
How about that?
About the law exam essay, the third is IRAC, and the second, we have a dispute here. Okay, so we have really different opinions, honestly. So court opinion is IRAC, so case brief is IRAC, some people say FIRAC, so very different opinions, to tell you the truth.
Okay, so here's the answers. Case brief, yourself, and to prepare the class for exams is FIRAC. Okay, that'll help you because you're looking at the facts. So you need that additional information to prepare yourself, right? So that's a good use of FIRAC there. For a law exam, you probably don't need to have the facts in there. Okay, your ability to do legal analysis, to provide well-written and organized essay. The facts are probably going to be presented to you in the prompt, in the question that you're receiving. So you don't need to restate the facts. Okay, that's the purpose for that. And then in the last one, to inform the audience. Well, the audience may not know, so they need more information. And IFRAC is what it's called. So you're going to have more information about the case, like the case information. You know, when was it heard on appeal? So you're going to have that kind of information. Remember at the top of the page when we had in our example of the Rail and Cadena case, where we gave information about the case itself. So maybe the judges and other litigants need to go back and review the case to see how it applies. So they're going to need that information. Then they're going to need the facts, the rule, and how it's applied, and then a conclusion. So you can see how it's used a little differently depending upon the audience. And the audience will determine the purpose. But it's a very useful structure, very useful tool. And brevity, being concise, is very important. Many times as a professor working with international students, the international students sometimes get confused when there's too much verbiage. It's verbose, there's too much. And it convolutes the issue. Very similar to what your ambassador was saying, our ambassador, Ambassador Sullivan. So legal writing exercises what we want to look at is how to be concise. That's extremely important. And I have students that come to Pepperdine University in Malibu, California, and they will come from all areas of the world. Many of them are from Europe or Asia. And one of the difficulties that they have is in translating accurately words and communicating or expressing themselves in ways that accurately describe what they're thinking. So that can be very, very difficult. I have a lot of admiration for people who are multilingual, especially at a very high level. And with English in a professional context, using English in the legal community or in a medical for doctors or engineers or people that are very high level, they have to have a very good vocabulary, not just in their own language, but also in English, because you have to use the synonyms and antonyms. And in order to do that, you have to be very well educated in your own language in order to cross-reference into a new language. And it is amazing as in terms of being precise and being clear, when you come to America, for example, to Pepperdine University at the law school there, the students will be learning new content. So they're learning the things that you are learning here today. And in order to learn them, you have to learn new content, but you also have to learn new language, okay? And how to put that in the proper context. And that's what we're doing with Iraq. So when unclear, put the subject next to the verb when you're writing in English. And we'll have an example here in a moment of each of these, so you won't have to try to guess what I'm talking about. I'll show you in a moment. To help the reader give signals, we use transitions. Okay, very common in English. A time order, dovetailing. You may not know what that is, but I will show you an example here in a moment. And parallel construction, outlines and titles and topic sentences. Outlines and are very common in the legal community. So we'll just take a look at some of the examples on that. So edit this sentence to be more concise. Give it a try on your own, and then you can see what I have done below here. So the first paragraph is what I want you to edit. And I've given you an example. This grievance is not arbitrable because it is excluded from the grievance and arbitration provisions of the parties. Collective bargaining agreement by the express provisions of that agreement, as well as by operation of law of the state of Washington. So it's a mouthful is what we call it. Okay, it's verbose. It has too much information that can be written more concisely. So how would you do that? That is one of the most difficult parts of writing, and one of the most difficult parts, not just for people that are writing in English that is a second language or multiple languages, but is a case where people who write in English as a first language have a very difficult time in writing. How do we make it concise? So example of that would be, this grievance is excluded from arbitration, not only by Washington law, but also by the parties' own collective bargaining agreement. We're essentially saying exactly the same thing, but by reducing it. And there's revision, and then there's editing. And revision is when you go through and you continue to revise what you've written to make it more concise. And the other issue is precise. You want it to be accurate. It has to be able to match the ideas that you were attempting to convey. I use something called arms and cups. And arms is when you revise something. So it's when you move things around and you substitute things within revision. And cups is when you do editing. So you're going to look for things in a very precise way. The first part of revision, of editing or revising your work, is what we've shown here, is how can I make it more accurate and more concise. How about subject verb distance? Okay, putting them next to each other is an example here. A standard form contract that detailed all the terms of the agreement except for the shipper's liability was signed by both parties. Okay. Instead, we might say both parties signed a standard form contract that detailed all the terms of the agreement except the shipper's liability. Okay. So we have the subject verb together here. Both parties signed a standard form contract that detailed all the terms of the agreement, compared to a standard form contract that detailed all the terms of the agreement except for the shipper's liability was signed by both parties. Okay, very wordy, very difficult to follow. How about transitions? Transitions. Washington courts do not determine nuance by subjective values, using the same example we had before. The presence of nuance is evaluated in objective terms. You add rather, the presence of nuance is evaluated in objective terms. Okay. So it adds more context. Extra. So I'm sure that I have the experience and background to contribute significantly to your company. I have been involved in cryptocurrency since college. I speak 3 languages fluently and have been educated on 3 continents. Since law school, ADR has been my specialty. Okay, to add additional context. Yeah. Order by time and subject, or dovetailing is what we call this. And you can see up there in the corner, there's a box here. And that image shows you what dovetailing is in terms of carpentry. You recognize that. It kind of puts things together and holds them together tightly. And that's what we're looking for. So having the first one, you might want to see if you can rewrite this. Give it a try on your own. Having copied financial logbooks that he took from Mr. Snodowski's private desk, Mr. Pugh delivered them to the IRS. Mr. Snowowski was tried and convicted on 2 counts of filing false tax returns after the IRS examined the log books Mr. Pugh had delivered. Okay. Let's see if we can make that a little more accurate and tie those together, those ideas. And you might write something like, Mr. Pugh took and copied financial logbooks from Mr. Snowowski's private desk and delivered them to the IRS. The IRS then examined the books and tried and convicted Mr. Snowowski on 2 counts of filing false tax return. Okay. So it's more accurate, more concise, gives the time and subject in a better, fluent way. Another one is parallel construction. What is parallel construction? Okay, we want things to be in the same sense. Okay, so we're going to look at this, and we have them in the first sentence here. The defense counsel elicited that the appellant paid for a listed telephone on in his own name, kept some clothes there, and the room was ready for him to be occupied. We can change this, because what we're doing is saying in the first sentence, the defense counsel listed that the appellant paid for a listed telephone for his own name. See what we've done here in the second sentence. We've changed it, revised it to say the defense counsel listed that the appellant had paid for a listed telephone in his own name, kept some clothes there, and had a room there that was ready for him to occupy. We put things in the past tense. Okay, So in the tense in this matters to put it all in the same context, so it's more accurate and accurately describes. That's parallel construction. Another thing we look at is outlines. So another way to argue your case and to make it so that it's more easily discernible for you is how do we put it in an outline? So attorneys are generally very good at this. You learn how to do this in law school, first year. Disparaging language serves an important role in society. Okay, getting back to our case. Reclaiming slurs has played a big part in personal expression and cultural debate. We might give some reasoning behind it. Rock music has a proud tradition of pushing the boundaries of expression. Disparaging language. Okay, and two, the government should not be deciding what's a slur. Okay, maybe that's your argument for the outline. It is impossible to draw an objective line as to what is disparaging. Maybe it's disparaging for one and not disparaging for another, for example. And should the government be involved in deciding that fact, or should it be left to the individuals to discern, to decide? And then brands that do not wish to offend can change their names voluntarily. We have this happen in America, and we just had this recently happen. Actually, today, a decision was made to change the name of a football team from the Washington football team, or the Washington Redskins, which is found to be an offensive or disparaging term. They're the Commanders now. They changed it from the Washington Redskins to the Washington Commanders. So even a name can be changed, a brand can be changed. And then number three, the disparagement clause violates the First Amendment. Okay, does it violate the First Amendment for free speech? Are you allowed to say what you like, regardless of the harm it might do others? Or, is that part of your rights? So we may argue that the disparagement clause is a viewpoint based on constitutional condition. Okay, that's one thing we could argue. A trademark is neither a subsidy nor an endorsement. So choosing which artists and speakers to fund with limited resources is different than trademark registration. Okay, speakers are different, artists are different. So we may compare and contrast using those terms. And then headings and subtitles. These are obviously very important when any writing is done, because they direct the reader to what is important. In these, we have the headings that are capitalized, whether Mr. Lee's Fourth Amendment rights were violated. The heading poses a question as well, when it should convey a conclusion. Okay, so it's asking a question whether Mr. Lee's Fourth Amendment rights were violated. Were they or not? We don't know. So the officers violated, right below that, number one, the officers violated Mr. Lee's Fourth Amendment rights. Okay, this heading is better because it states a conclusion, not a question. However, it would benefit from the inclusion of legally significant facts. How do we write those so they're more accurate in what we're trying to convey? And then the officers violated Mr. Lee's Fourth Amendment rights when they continued to search his car after he revoked consent. So in America, we have to give consent for the right for a search in many circumstances, unless there's a exigent circumstance. Somebody's in harm, or somebody's in the car that's yelling, it's on fire. There's some issue. Then it can be searched if there's prior evidence of a crime being committed. Okay, so this would be an issue to where you want to enter in that information. This example is better because it states a conclusion, provides the court with a reason why the conclusion is correct, and incorporates a legally significant fact. You may be arguing that your client revoked the right to consent, and therefore the search was done illegally. And in America, if the search is done illegally, the evidence that is found during the search can be excluded from the case and have a significant impact on the outcome, on the application and the conclusion of what has happened in the case. So very important that when writing headings and subtitles, that you accurately convey what you're trying to provide. And you can see they're very concise. Topic sentences. So topic sentences tell the reader what each paragraph is about. Keep your paragraph to one idea. Okay, that's always a key. In topic sentences, it's like a thesis for an entire paper. If you're writing a paper, you give the reader a thesis at the beginning as a map, as a guideline as to where you're going. The same thing is true with sentences, topic sentences in each paragraph. If it's another idea that's within the paragraph, then you need to start two paragraphs. You have to have another one. If there's multiple ideas, you have multiple paragraphs. Here are some typical ways to start a legal topic sentence. So court holding. In Baldwin, the court in Washington held that the garage was not part of the inhabitable structure of the home because the lack of an interior door connecting the two reduced the danger to those inside the home. Because, okay, you're giving a reason. So you're making an assertion and then you're backing it up for the reasoning. Because the lack of interior door, an interior door connecting the two reduce the danger of those inside the home. So general court holding. Courts have held that a person can be considered armed with a deadly weapon even when the act of stealing it, okay? So courts have held that the person can be considered armed with a deadly weapon even when in the act of stealing it. In Cruz, then you're going to give information. Courts look at, which is the topic sentence here, to determine if an object is a deadly weapon. Courts often look at the surrounding circumstances of its use. Specifically, the Baldwin court looked at such factors as time, place, nature, and. So courts looked at, it refers to what we want the court to review. It points at what we want it to review. And then application paragraphs. Unlike the facts of Baldwin, here, the client is not in the act of stealing. Here, so we're giving the application, directing the court. I'm right at the 9:30 my time, and I think it's probably, 8:30 your time, right at the end. And I think we could probably go to some questions.
Yes. Hi, Daniel. So can you hear me? Here is Sophia.
I can.
Yes. So hi, everyone. So my name is Sophia, and I'm the head of Legal English Center in St. Petersburg. Thank you very much, Dan, for your presentation, for being with us. I understand how difficult it is to be talking into the wilderness when there is no response and there is sometimes a voice coming out of the blue. So we understand that it's extremely difficult and we appreciate it. Thank you so much. We do have quite a lot of questions actually, and they can be basically divided into two big portions. Some are related to the writing, some are related to some general aspects of law. So let me speak about the writing first, okay? So first of all, what is, if you can just explain very briefly, what is the difference between brief and memo? Because technically in Russia, we don't have briefs, we have different court papers. So, and some people were confused a little bit, and should there be different structure between them? If you just can briefly speak.
Yeah, the brief is more of a legal document that is provided to the court, just as we had a good example of that with that case that I provided. So each of the students should have that case with Rail and Kadena.
Yes,
and
we uploaded it onto the website, so everyone can look at it later on. So, and some looked at it before. Mm-hmm.
Perfect. So, and there are different uses. You know, what you use the brief for is to provide legal information in a concise format. Again, there are similarities and differences between the two. So that brief provides the legal community with almost like you would say an abstract that you might see on a journal article if you're going to look it up, or on Google, where you're going to search something and you have an abstract. It's very concise information, but it's put in a formal legal form, that gives you the court, the jurisdiction, the year, gives you a lot of information there. But it's done in a context of using it for searchable content and a summary.
Okay.
Wherein what we're doing here with the memoranda, we're using that for the purposes, as I showed. I think I can go back here.
Mm-hmm. No, we cannot. So we cannot turn on the presentation. Yeah, it will be a little bit difficult for us right now.
Yeah, we had a question there, and if you recall, the question was, how do we use the IRAC or IFRAC or FRAC? How do we use those in which context?
Yes.
So we had the case brief, law exam essay, and the court opinion, and we use those in order to fulfill the purpose. So the purpose was for taking an exam, for example, for that memo, or for, if you recall earlier in the presentation when I spoke about, are you preparing it for your client in order to brief the client? Are you preparing it in order to provide information to the court? So it has different contexts that we use them in. So for a student, when you're preparing for class exams, you would use the FIRAC, where you have facts in the issues and such, but it's done in a different format than you would for a brief.
Yeah. Thank you very much. Yes, we usually, when we speak about drafting the memos for clients, we usually even try to teach that we use CIRAC, if I may say so, structure. So, because if it is a clients usually want a very precise answer. So you give them conclusion first, and we call it very often, if people work in consulting, they call it executive summary, and they even name it like this, a heading. And then if the client wants to, they can go further and have a look and see all the analysis and so on. So, and it's very strange usually for Russian speaking people, because we are used to writing. So we need to show how much effort we made. We need to take the reader on a quest sometimes, and then at the end, the word with the conclusion. And the idea is that you can give everything at the very beginning and topic sentences as well, which is basically a summary of the paragraph. It's really mind-changing that you give kind of the summary first, and then you speak about the details. So it's very interesting. Thank you very much. Yeah. So then another question was that speaking about outlines are like a skeleton of the whole memo. Yes, as one of the our participants said. So it's like a skeleton you create with the help of headings, or like you structure your memo and guide the reader. So is it correct, as some of our participants understood?
That is correct. Yeah, it's creating a skeleton and ensuring that you have things in the proper sequence as well. Not just that you're arguing various aspects of the case or presenting information and content, but you may have to reorder them depending upon how you're. In America, we have a jury, and that jury consists of people that are from the general public. They're peers, and those peers could be a bus driver, a policeman, it could be a school teacher, it could be a doctor, or even an attorney. Judges have served on the jury.
Oh, they do serve as jurors.
Yeah, they do. In many of them, and at Pepperdine, we have judges that are retired, that are a part of the faculty, and they brag, and they're very proud of the fact that they're able to serve on a jury. They feel it's not only their obligation as a judge to be in the position they hold in the judiciary, but also in society, that they have that honor and that right to do so. So when you're arguing in front of a jury, it's different than arguing in front of a judge or a tribunal, where you have educated, knowledgeable people that you're just simply arguing the case law or the facts. In a jury, you have to educate them as though they know nothing, because maybe they don't. So in structuring your outline in that framework, you may have to reorder your arguments so that it makes more sense to people that are peers rather than professionals in the legal field.
Yeah, thank you. So this is also very open-minded that a judge can be a juror. Thank you very much. And also, I think the final question about the structure of a memo. So, and then there will be one more question about actually plain English versus old-fashioned language. So the final question about memos. What do you think? We usually say that the person who is drafting a legal text, a memo, so needs to have like two roles. First, role of an architect, when you structure the text with the help, when you create a skeleton, when you create a structure of the text with the help of headings, topic sentences, and so on. And then you're like a carpenter who is very, very detailed about the grammar, the prepositions, the articles. And some lawyers say that actually they think that structure is more important than some typos or mistake in the language. What do you think?
You know, I like the fact that attorneys can use both structure and abstracts. So you have to do both. And many times attorneys struggle with this because they want to be letter of the law.
Yes.
So the first thing I would start with, and that's using that madman theory, the madman's theory of structuring.
Brian Gardner, yeah.
Yeah, and I love that because we start with the crazy man, the Einstein, right? That throws everything. And so you don't start with an outline that is structured. You start with something that is the whirlybird, if you recall from his theory, where you redesign and you throw out ideas, and then you come to some conclusions you may not have thought of. And then you go to the architect, who then designs the structure of the memo. And then you go on to the contractor that builds the argument. And then finally you come to the judge, and the judge says, no, not good enough, start over, or disregards certain parts and throws it back to the proper person.
And from my experience, very often people are so tired by the end of being a judge, they just send it and are afraid sometimes to reread it. So, and they're afraid to take this role. So then two questions, actually. I have one more that I have. So the final question about the writing. What do you think about old-fashioned English words like shall, hereby, there, thereon, whatsoever in contract? In contracts. We're going to talk about contracts next time, and the 3 classes we're going to dedicate to them. Are they still applicable, or should not they be used by lawyers, all of these witnesses and so on?
Yeah, you know, the problem can be one of context. So it's one of those things in law to where you're saying it depends. And most of the time, accuracy is important, but there are times when maybe a case might need some flexibility, or something might need. So as you can see, it would depend on the circumstances. Do I want to leave some wriggle room so that it's not so tight that it has to be held to a certain standard? Most of the time, you want it to be accurate and have no wriggle room. You don't want to have it misinterpreted.
Yes.
So you
don't
want
want any ambiguity or vague.
No ambiguity.
Yes.
But there may be some situations, and I've seen this, in which it has been intentionally made so that it can be interpreted differently.
So you have some leeway in case of some.
Yeah. Most of the time, you don't want to put them in there, but there may be some situations to where there's an exception, is what I'm saying.
Yeah. Or sometimes when you use passive voice, And sometimes it's kind of a signal right now in the modern writing, like, why is it used here? So maybe you just want to take off the responsibility from your shoulders sometimes. Okay, thank you very much. And the final question, just the final, there was an expression which you used, which is called black letter law. And our viewers didn't get this. What does it mean, black letter law?
Black letter law. That's another way of saying exactly what the law says, not no ambiguity. Okay. So you're simply taking it. Yeah. You're simply taking it from what the law says, what it's written, and not trying to interpret anything other than what it specifically states.
Okay. Thank you very much. I would like to thank you. Thank you so much for being with us tonight. We're wrapping up. We're finishing up. And we are very grateful to our viewers. Thank you very much, Dan. Thank you very much, those of you who joined. Thank you very much for being so enthusiastic in chat. We will fix some slight technical issues, so we'll deal with it. It was the first time. We are extremely excited, and we invite everyone to come and join us in 2 weeks. And we will start a module about contracts, and then we'll speak about the language of contract law and major contractual provisions. Very specific, what everyone needs, contract. So you're all very, very welcome, and see you. Thank you, Dan. Bye everyone, and you are very welcome to rewatch these videos. You can see all the additional materials up on the website, and see you in 2 weeks. Goodbye. Bye.